On the legal front, what is next for pro-life advocates in the battle against mifepristone? And how will this decision shape discussions in state courts?
To help us answer those questions and more, we are joined by Mark Rienzi, President and CEO of the Becket Fund for Religious Liberty and a law professor at the Catholic University of America. Mark, welcome. Court watchers do not seem surprised by this technical loss at the Supreme Court. Why is this rejection of the pro-life doctors' claims unsurprising?
Thanks, Catherine. Thanks, Montse. This is not that surprising, given the way the argument went. And it's important to stress that this is a decision that doesn't address the merits of the claim at all. In other words, the Supreme Court doesn't say what the FDA did was right or wrong. They really just say these plaintiffs aren't the right people to come sue about it. And the reason the court said that is they said that these doctors aren't really harmed by the FDA changing its regulations about how to administer mifepristone. And once the court decides that the doctors aren't harmed by it, then usually they can't be the ones to bring a case.
Putting on your law professor hat now, since the merits of the case, whether the FDA did the right thing in loosening the requirements for doctors prescribing these drugs were not addressed, is there an opportunity for a different kind of case to be brought to the court that will protect patients and make mifepristone less available?
Yeah, I think it's possible, but it's difficult, which is why the case ended up this way at the Supreme Court. But you could imagine somebody who has been harmed by the change in regulations. In other words, one of the changes was that you no longer have to have an in-person doctor visit for parts of the process. So you can imagine if someone's been injured by that they might be able to challenge it and say, well, I have been harmed, right? Those doctors in this earlier case maybe can say they weren't harmed, but I was harmed because I was left alone in my apartment while this was going on, and I didn't have the doctor visit that the original rules said I should have. So you can imagine a claim like that, but it's pretty hard to change regulations that way.
Well, Mark, the court's opinion makes some significant statements about the rights of doctors to object to abortion and their exceptions from providing abortions in emergency settings, the subject of another pending case before the court this term. In light of that, how significant is it that this is unanimous?
Yeah, I think that is a real silver lining to this decision, is that you do have 9 justices saying, look, federal law protects healthcare providers from being forced to provide abortions against their will, even in emergency circumstances or claimed emergency circumstances. And to do that, the court actually wrote into the opinion several concessions that the Biden administration made while arguing the case. So I do think this opinion does move the ball forward on making clear that those protections are real, that is the right way to interpret federal law. This is not something that you had, 5 justices on one side, 4 justices on another, saying, here's how you interpret the conscience laws. Instead, all 9 agreed that those conscience laws protect the doctors. The downside for this case was that since those laws protect the doctors, the court said the doctors don't have anything to fear from this change in the rules, therefore they had no case. But for the future, it means the court has interpreted those laws broadly and clearly in a way that I don't think future federal governments could get around.
Well, Mark, let's get into that silver lining. While the admission in oral argument by the Biden administration that broad and comprehensive conscious objections for doctors are protected by the Constitution, does that protect them from regulations made by other agencies like the Department of Labor or Health and Human Services? We know that you have cases surrounding that.
Yeah, I think it does. I think it makes absolutely clear, and again, all 9 justices agreed on this, but it makes absolutely clear that if the government is trying to force you to violate your religion, that's a real injury, and that would let you into a case. The problem here was they said these doctors can't say that because they haven't been forced to violate their religion. But in other cases where the government is trying to force you to violate your religion, this opinion's super clear, both that that's an injury that lets you get into court, and also that federal conscience protections stop the federal government from doing that. And those conscience protections apply whether it's Congress or whether it's an agency that's doing that to people.
Mark, this opinion did have one concurrence from Justice Clarence Thomas. He noted that pro-life doctors are not allowed to claim harms on behalf of their clients, something that Planned Parenthood and pro-abortion groups have done for decades, we should note. Was Justice Thomas, was he foreshadowing future losses for pro-abortion groups, or was he simply telling pro-life groups not to adopt those same strategies?
Yeah, it's always tough to kind of get into the mind of a justice and know exactly what he's aiming at. What he said, though, was that we should take Article 3 seriously, and Article 3 basically just limits the courts to hearing cases where someone's actually injured. And Justice Thomas is always very clear and careful about the language of the Constitution. And he said, look, our doctrines about who gets to sue over things have been bent out of shape a little bit in the last 50 or 60 years. And Justice Thomas is telling the rest of the court we should think carefully about those other doctrines and really enforce them so we get at the real meaning of the Constitution. So if others on the court come around to those views, then that may lead to a tightening of those doctrines. Right now, we just know there's one justice who thinks that.
Mark, the Supreme Court has recently been under fire for seeming partisan. Was this decision meant to send a signal about the court's impartiality or an interest in protecting the rule of law, especially to critics who claim the conservative justices are ideologues and activists? We know many of the justices are personally pro-life.
Yeah, I think it does send at least some of that message. You know, I think there's a lot of people who don't want to hear that message, frankly, and who emphasize and like to emphasize the partisanship. But yes, right, this is a case where several justices who voted to overturn Roe versus Wade are coming back and saying, but the pro-lifers don't win here because they take the Constitution seriously. And so I think from their point of view, they say, look, this demonstrates that I'm serious about the job. My job is to interpret the Constitution. That doesn't mean the side that you want to win always wins, but it means you have an oath and an obligation. And I think the case shows that they're taking that seriously. And I think the unanimity does help. I think there are some people who like to pit everything as these angry 5-4 hotly decided decisions. And oftentimes the justices do agree on a lot more than we're told they agree on.
Mark, finally, our last question for you. Both Justices Kavanaugh and Thomas noted the limitations on the power of the courts, both in addressing this issue, where justices told the pro-life doctors that the executive and legislative branches were a better forum. Are they suggesting Americans are over-reliant on the Supreme Court?
I don't think they say that, but I'm sure that's part of the thinking. And you see the Supreme Court do this from time to time. Chief Justice Roberts did it years ago in the Obamacare case. But yeah, I think the justices do like to send the message that our job is a limited job, right? When we're the judges, we decide real cases and controversies from real parties who've been harmed. But we don't just fix every law that's bad. If there's a law that you think is bad, you should think about that and go vote for somebody who will change that rather than expect the courts to fix all the problems. So ultimately, I do think the court was emphasizing its limited role in our constitutional democracy and therefore the bigger role for the people and their elected representatives to fix a bad law if you've got a bad law.
An important reminder in an election year. Thank you so much, Mark.
Thank you. Good to see you both.